briefly about PEC before I turn it over to our moderator. Piedmont Environmental Council is a nonprofit that's been operating for almost 50 years now in a 9-county region from Loudoun down to Albemarle County. Our mission is to promote and protect the natural resources, rural economy, history, and beauty of the Virginia's Piedmont. We do so by educating and empowering our citizens to engage at the local, state, and federal level on significant policy issues that impact their life, as well as an accredited land trust preserving land in our region. And so without further ado, I'm going to turn it over to Hallie Plourde-Rogers with the Virginia Eastern Shore Land Trust, and who will act as our moderator today. Thank you so much. Hallie?
Thank you, Dan. And welcome everyone. Thank you for being here today. We're really excited to have you here and to have our speakers with us as well. So as Dan said, I'm Hallie Plourde-Rogers with the Virginia Eastern Shore Land Trust. And VES Land Trust protects the rural lands which best preserve the farms, forests, wetlands, and waters and heritage of the Virginia Eastern Shore, so we're Accomack and Northampton counties, for the benefit of future generations. So along with our partners, I just want to thank you for joining us and welcome you today to our webinar, Keeping Land in the Family. I'm going to briefly introduce our other partners. So we have Virginia's United Land Trust, and Vault supports Virginia's diverse conservation community to magnify and amplify land conservation efforts and achieve widespread protection of the Commonwealth's natural, cultural, and scenic resources, ensuring their long-term benefits for all Virginians. The Black Family Land Trust is dedicated to the preservation and protection of African American and other historically underserved landowners' assets. Through land conservation and land-based community economic development, the Black Family Land Trust provides families with the tools necessary to make informed, proactive decisions regarding their land and its use, and measurably improves the quality of life for landowners. The Capital Region Land Conservancy conserves and protects the natural and historic land and water resources of Virginia's Capital Region for the benefit of current and future generations. So a really big thank you to all of our partners for helping us with this webinar today. So on the webinar, we're going to review what is heirs property, and we're going to explain the basics of the new Uniform Partition of Heirs Property Act. The act was passed unanimously this past legislative session and became law on July 1st, 2020, thanks to our legislative patrons here, as you can see on your screen. Delegates Patrick Hope and Michael Weber, and Senators Frank Ruff and Jennifer McClellan. And we are lucky to have Jennifer McClellan on with us today. So thank you for joining us, and thank you to all 4 of them for helping us get this legislation passed. And without further ado, I'm going to introduce our speakers. So we have 3 presenters today: Ebony Alexander, Executive Director of the Black Family Land Trust, and David Gogol here, Principal at Blankenship and Keith. And we hope that we'll hear a few words from Senator McClellan as well. So Ebony Alexander is the Executive Director of the Black Family Land Trust. Since joining the Black Family Land Trust in 2009, Ebony designed and implemented the African American land ethic and wealth retention and asset programs. Together, these 2 programs help landowners retain family ownership and control of land assets. Ebony currently serves on the American Farmland Trust, the Sustainable Forestry Initiative, and the North Farm Stewardship Association. In 2020, Ebony was awarded the Gerald P. McCarthy Award for Leadership in Environmental Conflict Resolution from the Institute of Engagement and Negotiation at the University of Virginia. Ebony is a native of Maryland and lives in rural Virginia on land that has been in her family for generations. Senator McClellan, who co-patroned the UHPHA legislation in the Senate, is an attorney who served in the House of Delegates for 11 years and since 2017 has served in the state Senate. Her district includes all of Charles City County and parts of Richmond and Henrico and Hanover counties. She is serving on the following committees: Agriculture, Conservation and Natural Resources, Finance and Appropriations, Judiciary, Privileges and Elections, and Transportation. And last but certainly not least, David Gogol is a civil litigator with over 30 years of trial practice, primarily before the various Virginia circuit courts in Northern Virginia, as well as the federal courts for the Eastern District of Virginia. He also has substantial appellate experience, arguing before the Supreme Court of Virginia and the United States Court of Appeals for the Fourth Circuit. His practice has concentrated on commercial litigation, employment law, real estate law, legal malpractice defense, and appellate representation. David is an active member of the Virginia State Bar, and he serves on the Board of Governors for the Virginia Bar Association, the Civil Litigation Council, and the board of the Virginia Law Foundation. He is a member of the Virginia Continuing Legal Education Committee and has been an active member of the Boyd Graves Conference. David received both his undergraduate and law degrees from UVA. I hope I didn't miss anything important there. We have some really wonderful speakers here and they have great experience, and I am really excited to hear from them. I hope you all are too. So we are going to start off hearing from Ebony Alexander, and I will pass it over to Ebony.
Thank you, everyone, and good afternoon. Thank you for joining us again. I am Ebony Alexander, Executive Director of the Black Family Land Trust, and we are dedicated to helping African Americans and other historically underserved populations retain their land assets. We view land as an asset. It should be a performing asset for current and future generations. And that's the motivation behind all of our work, is to make sure that the land stays in the family and that it is there and available for many generations to come. My role today is to tell you about how we got to coming to Vault and asking Vault to work with us to get the Uniform Partition Heirs Property Act passed and adopted in Virginia. We are a member of Vault as a land trust, and it was my great pleasure to work with you, just a wonderful group of people on a coalition that we formed to get the job done. We managed to do it using technology. We all did our part. We spoke on the phone every month. Everybody had a chore. They did their chore. And I think some of us, had we walked past each other in the grocery store or in a mall, we wouldn't have known who we are. But if you heard someone's voice, you'd say, oh, you're on that committee. So it was just a wonderful experience. And I can never say thank you enough to everyone. Let me tell you a little bit about how we came to this. Heirs property, in layman's term, is when you have multiple generations that own the land. And usually it is, and they're all family, and land is transferred from one generation to the next by blood. So just imagine you have your parents, and then you have your first cousins, and then you have your second cousins, and your third cousins, and all of you own the same piece of land. And that's what heirs property is. A lot of times you'll see people take a picture of a pie and see the pie get smaller and smaller. But just imagine having a family reunion and everybody at that family reunion owns the same piece of land. And then you have to try to get them to 100% agreement to make a decision about what you want to do with this land. Now, I know I only had one brother, no sisters. We rarely could agree on anything. I can't imagine having all of my cousins. I have 68 first cousins. I can't imagine having all of them agree on anything as it relates to a piece of land or anything else. So with heirs property, you have one piece of land, you have multiple ownership. And then what we have found is that people really want to do something about heirs property, but there's some barriers. And the key barriers are, one, access to education, two, access to trusted and affordable legal services. And then the third one is access to capital, if you want to buy your family members out. What we say about heirs property, it is not an issue of geography, ethnicity, gender. It is an issue of not having access to those three things that I just spoke about: legal services, education, and finances. If you live in Buckingham County and you have 100 acres of land and you die without a will, you've created heirs property. If you live on Broad Street in a $100,000 condo in Richmond and you die without a will, you've created heirs property. So creating heirs property is the first step that we have to address, and how we stop the creation of it. And that's by making sure everyone has a will, and other speakers will talk more about that. But what we know in the work that we do is most of our landowners are living on family land. They want to do the right thing, but they just don't have the resources, either legal or financial, to be able to do that. The other thing that we know about it is that as land is a finite commodity, this is it. God's not making any more. And our role as a land trust is to help protect just the land asset for current and future generations, but also to protect the land as stewards of land, conservationists and environmentalists. So having said that, that was the backdrop to our approaching vault back in 2019, after being asked by Thomas Mitchell, who said to me at a meeting, Ebony, can you help us get this passed in Virginia? At that point, there were only 14, I believe, states that had passed the Heirs Property Uniform Partition Act. We approached vault, they said yes, and we went to work. One of the motivating factors that helped us was the fact in the 2018 Farm Bill, USDA said that if you have a state that has adopted the Uniform Partition Act, then those landowners can participate in some of the USDA programs. And that was a big plus for us, because that then allowed our landowners to access resources through USDA to put their land back into production, to make that land a performing asset once again. So we used that, we formed our committees, we spoke, we decided that we would get patrons from urban and rural and from both sides of the aisle, so that we could show that this was not an effort that was a partisan effort, but truly an effort to make sure that we were protecting the land and helping landowners, helping our fellow Virginians be able to protect their land assets going forward. To all of our amazement, we were able to do this fairly easily until we hit a little brick in the road where we had to come. David Gogol was just masterful in helping us to get that through the Boyd's Grade Committee. And I think, and I know, we've been told by both Thomas Mitchell and some other legislators around the country that Virginia has one of the best Uniform Partition Heirs Property Acts in the country. I want to make sure that we have time for Senator McClellan to make some comments. So I'm going to stop there. And if you have any questions, please feel free to ask us the questions. Hallie?
Thank you, Ebony. Really appreciate hearing from you. And if Jennifer McClellan and Senator McClellan, if you have a few things you'd like to add, please feel free at this time.
Thank you, Hallie, and thank you everybody for having me here today. And I wanted to sort of just talk about this from a public policy perspective very briefly, and to a certain extent, a personal perspective. I think everyone from the beginning of the founding of this country, before we even were a country, land was valuable. Land was wealth. As a matter of fact, for a long time in this country, it was only landowners who were allowed to vote and were the power holders because of the understanding of how important land ownership was. And the way we even structure our tax base in the Commonwealth, particularly at the local level with taxes being based on real estate, showed that from the beginnings of this country, how important land ownership was to the accumulation of wealth. And that in a way baked inequity into the system, because those who had access to lawyers could keep land that they earned, or their family earned, and those who didn't couldn't, for all the reasons that Ebony pointed to. And we see the ramifications of that today. You cannot talk about wealth gaps and particularly racial disparities in wealth if you don't fully understand the role that heirs property played. And I think David Dietrich, who was the former co-chair of the American Bar Association's Property Preservation Task Force, pretty much summed it up well when he said, heirs property is the worst problem you've never heard of. And particularly among African Americans, it was the leading cause of involuntary land loss. And it was estimated that 3.5 million acres of land worth more than $28 billion was lost to Black landowners solely because of heirs property. When this bill was signed at Ralph Sampson's farm right outside of Harrisonburg, he told a story about how they almost lost the family farm that his grandparents bought 80 years ago. But because of the Black Family Land Trust, they were able to keep it. But there's so many families that have lost land, including my own. My mother was one of 14 children. And her parents, her mother predeceased her father, and her father died without a will. And the land was divided among the 14 children, and her oldest brother had 16 children. So just through that alone, you can imagine how difficult it was to figure out what to do with that property. And some of it was lost. Some family members still live on pieces of it. And my grandfather had land that is now a golf course, primarily because of heirs property. And it's something that we could do something about through this legislation. But I wanted to not just talk about the legal ramifications of why it's important, but just even today, the American dream is owning land and making sure that we do everything within our power to make it easier for families to maintain land. First, to reiterate what Ebony said, making sure everyone understands the importance of having a will and how to protect all of their assets in the event of their death, but also just making it easier for families to keep land in the family and have control over its disposition, rather than some stranger showing up on your door one day knocking and saying, I now own a majority of this, and I'm going to force you to sell, even if this is land you may have lived on your entire life. So that's what was at stake in getting this legislation passed. And I'm grateful, frankly, that we were able to get it done quickly, relatively quickly, and unanimously. Anytime, I remember when I first heard the term heirs property, I thought, what in the world is that? And we're going to have to explain that to 140 people, and that's going to take forever. But we got it done. And that's thanks to Ebony and David and many other people, some of whom you'll hear from today. But this is probably the most significant legislation we passed this session that hardly anybody is talking about. So it is my pleasure to be here to talk to you all about it today and help you learn a little more about it.
Thank you so much, Senator McClellan. Thank you for that perspective and also for sharing that personal story as well.
Thank you.
I think with that, we will head over to David.
So I just wanted to start just very briefly, and just very grateful I had the opportunity to have a role in this process and work with so many great people to get this legislation through. Just very quickly, what Boyd Graves is, Boyd Graves Conference is a volunteer group of about 100 lawyers and judges and one Supreme Court justice that every year meets and tries to troubleshoot and fix problems with civil procedure and civil remedies in Virginia. And in the spring of 2019, I was asked to chair the committee on the Uniform Heirs Property Partition Act. And it was, we were told that there was a Senate Bill 1190 that was tabled for review, and the legislators wanted Boyd Graves to take a look at it. And SB 1190 was essentially the model act. And so we met over the summer of 2019 and realized that we're really thankful that it was brought to us, because the act had a lot of very great reforms that we thought would be very good for Virginia to adopt. But we really thought Virginia could do better, and that the idea of creating a separate scheme that was for heirs property, but heirs property was defined inherently was a very broad and definition and very arbitrary because you couldn't really define it socioeconomically or to really identify the communities that were being harmed. And so, but the realization was that the reforms were important enough that they should be adopted whole scale, universally in the partition statute. So we recommended that the bill not be adopted as it was presented, and that instead Virginia do better and work over the course of next year on a legislation that would adopt these reforms for the entire statute and improve on it. So, but we were told in October when our committee made the report that the legislators really wanted that reform sooner. So over the course of several weeks in November, December last year, we worked with the Uniform Code Commission and meetings with several folks who are on this call, I'm sure. And we drafted the legislation that we think is a much better approach. And I'll try to explain why Virginia's approach is better. If you consider the evil that the uniform statute's trying to address, it's that heirs property, which is held tenants in common. There's the remedy for that property is partition. In other words, if you have several owners who all jointly own property and they can't agree what to do with it, the partition statute is the remedy for them to address the fact they can't agree on what to do with their property. And in Virginia, we have a very strong preference for partition in kind. And what that means is that land is so valuable and so sacred that if someone they can't agree, then we try first to separate the land so that everybody has some. And that worked really well when you had lots of acreage. Of course, doesn't work very well for a single residential home. So the other option is allotment, which means that perhaps one of the parties might agree to buy out the other. And then if not, then the property can be sold. The evil that this statute was trying to address was the disadvantaged communities that would own this property, as Ebony described, over the course of many generations. And Professor Mitchell, who's who drafted the Model Act, he pointed out that like Hilton Head Island was largely a lot of African-American owned property. And developers were able to go in there and find one heir, of maybe 30 or 40 for a very prime piece of waterfront real estate and buy them out for a very low amount because there was not a market for buying that, except if someone wanted to bankroll a lawsuit for partition. They then would seek partition in court and then persuade the court that the property could not be, it was more valuable to sell it whole and then have a court sale far below market value and essentially steal the land. And this was a problem very largely in the South and in the West and areas where you had historical racism and the courts and the were not very mindful of the prejudice that was going on, or just basically were a source of abuse. So I mean, it was a big problem. I think what we recognized in Virginia, my committee, was that we had not experienced that problem to the same extent in Virginia as maybe other states. I think in Virginia, where we see the problem more is with tax sales, and that's another subject, but you have the same problem with heirs property, and we lose a lot of heirs property, a lot of African-American community loses property through tax sales, and that's another area we need to reform. But the basic four reforms that the Model Act sought to use, the first one was the court-ordered appraisal, the idea that a developer will have a hard time coming in and getting this property if there's a court-ordered appraisal that would set fair market value. And in my practice with partition, it's a battle of appraisers. And we basically, both sides, it's usually, or maybe it's three sides. I had a case where there were three different owners and we each had our appraisers and we both all spent money on appraisers, and then the court ended up trying to decide which appraiser was the closest to being fair, because they were almost like really advocates. You hire an appraiser, you meet with them, they end up not being quite as objective because they're really understanding your viewpoint, not hearing the other viewpoint. So it's not that they're overtly biased, but they're being hired to present your sort of view of what the land's worth. So it's an expense that nobody really should have. If you can have the court order appraisal, it really would save all parties to partition. But uniquely for the heirs property problem, it would set a benchmark for value. So that was a really important reform that our Virginia legislation does adopt. The second was the buyout provision. And essentially what the Model Act says is that, if you buy an heir's property and you seek to have it partitioned, you're going to be disqualified from getting an allotment. In other words, you're going to be disqualified from persuading the court you should be the one to get the property. And it sounds like a great deterrent. In fact, is a very good deterrent. But when you consider the definition of heirs property, and it really, under Virginia, that the definition is so, under the Model Act, it's so broad, it really is most property. It would also apply to a house that maybe the parents died without a will and was left to 3 siblings, and one of them was doing most of the work, paying the taxes, doing a lot of the effort to rent it, and couldn't get the others to really help, and wanted to have that allotted. Well, the Model Act would prevent them from actually having that remedy. So we quickly realized that a better approach would be to essentially create a 3-level sort of inquiry. The first level would be, still, Virginia has a strong preference for partition in kind. Can this property be divided? Is it susceptible to a practical division? And if that's the case, that's what happens in a partition action. And the second would be the allotment. And in the allotment, what we would do is we would adopt the Model Act's. The Model Act has this totality of circumstances test. And in the second stage, in the allotment, we would adopt the factors from that test, which all favor the heirs. And I can sort of point them out to you. The collective duration of ownership, a co-tenant's sentimental attachment to the property, the lawful use being made of the property, the fact that the heir is actually farming the property, the degree to which the co-tenants have contributed their pro rata share of property taxes, insurance, and expenses associated with ownership over time. So a developer would have a hard time coming in and arguing for allotment in the face of heirs who are favored by these factors. So the Virginia approach would do that, and you only get to a sale if you can't do an allotment. So now the Model Act adopted just the totality of the circumstances test, and that theoretically would allow a party to say it's more valuable to sell than to partition in kind. And so we think that Virginia is actually stronger because we have kept that strong case law preference for partition in kind. So that's one other way in which the Virginia Act is different. We also adopted the open market sales approach. So now the practice in Virginia, which is generally to have open market sales, is now enshrined in statute, and that's another reform of the Model Act. So, the big way that I think Virginia's approach, I think, is, you have to look at why was the Model Act crafted the way it was. And it's crafted to say to legislatures, look, we're not going to ask you to change your partition law, whole scale. All we want you to do is adopt this Model Act that would allow for heirs property to be treated differently. And that is a really good way of going across the country and persuading legislatures that we're not trying to ask you to do too much. We're just asking you to do something that affects heirs property. But I think the better approach is if these reforms are really that good, and you don't want to have to get into fights on whether property is heirs property or not, then you adopt the reforms throughout the whole partition statute. And so I think that's why it's helpful for Professor Mitchell in his efforts to spread the good news of addressing this concern, to have a model that actually looks at a whole scale revision of the partition statute and doesn't create a subset for property that's defined as heirs property. And it's a very arbitrary definition. So I think that's in essence how we came up with a different approach. And I guess I wanted to leave some time for questions. So I think if we can maybe turn it over to some questions.
Yes, absolutely. Thank you, David. Thank you, Senator McClellan, and thank you, Ebony, so much. I'm Ellen Shepard. I work for Virginia's United Land Trusts. We do have a couple questions, but if, as Marco said, please add them into the chat. One, I just wanted to point out one great resource is the public libraries. And I know this is part of the reason, the inspiration for starting this webinar is some of the work on the Eastern Shore. And it says that families, that libraries do have some templates and forms you can use to help write a will. So that's just a good free resource. And then we had a couple more questions. I did, before we get into the questions, Ebony, I did want to talk to you or ask you a question 1 minute about the importance of putting together a family tree and trying to work through heirs property kind of as a first step before we get to the courts. So if you wanted to talk about that for a minute.
Okay, thank you, Ellen. The family tree is probably the most important thing that you can do as you begin to address the heirs property. As I said before, the land ownership follows the bloodline. And that means everybody who's in the bloodline. Doesn't make any difference whether they were born within or outside of a marriage. They have to follow the bloodline. How we do that can be very difficult. What I recommend to our clients is start collecting every obituary that you can find. Start with obituaries, start with family Bibles, and don't try to do it all at one time. Break the family up into branches. So each subset of family members, let them do their own, and then meet periodically to make sure that you're in agreement that all of these are in fact the legal heirs. One of the issues that we have in the African-American community often is children will be raised by someone who is not a relative. Those children, unless legally adopted, are not heirs, and that can create a rift within the family. So one of the things that we encourage people to do now, of course, is do a will, but also you've got to do a lot of education, a lot of upfront work with families. One, most people don't trust you whether you're talking about heirs property or not when you start to come in and talk to them about their land. Two, you've got to be able to be culturally sensitive to each family. You know, what has that family's experience been? When you listen to a family and they say, we now have 35 acres, but my great-grandfather had 135 acres, and we lost some to this and we lost some to that, that's a warning sign. That's a red flag that you have to tread very carefully with this family. So what we advise you to do is to keep records of death certificates, birth certificates, marriage licenses, and most importantly, with obituaries. Family Bibles help, but obituaries, usually people tend to be a little bit more honest in an obituary than they may be if you're just talking to them face to face. But that's the first step. Let me also add, Ellen, the other first step along the same parallel track is starting to reach agreement with what you want to do with the land. You've got to get consensus. How many people want to keep the land? How many people want to sell the land? How many people didn't even know that they were heirs to a piece of property? All of that is important. So you've got to run those parallel tracks at the same time.
And Ebony, some of that can be done with attorneys, and some of that can also be done with mediators, right? I mean, that doesn't always, there are options when sometimes that's a good approach.
Absolutely. It is more cost effective because of the time that it takes to do this, to do it as a family unit or use mediators or use another nonprofit. We help families do that so that you can build this family tree. And then once you get the family tree built and you have some consensus that this is in fact the family tree, you need to make sure that you have phone numbers, addresses, emails for each one of those family members so that they can be contacted. And then the other thing that you have to do is then start making sure that you know who's in which camp, who wants to sell, who wants to keep it, who's just not sure what they want to do. We always say, if you could get more people in your camp to keep it, then that's better for it at the end of the day.
Senator McClellan and David, I'm going to put this question to the two of you. What can be done at the town and county level to educate representatives about changes and how it can eliminate blight, this policy change?
So I would say in general, making sure that any organization that you're a part of is spreading information, whether it's through town hall meetings, whether it's through newsletters. We have a series of op-eds that were published when the law was first signed. I did one in the Richmond Free Press. I know there was one done in the Richmond Times-Dispatch. The Secretary of Agriculture, Patina Ring, wrote one. We can get those to you if you want to share them or repost them or have them reprinted. But just using every opportunity to spread information far and wide through a wide variety of mediums just about the fact that this law exists is important. And then David, I'll turn it over to you to add anything onto that.
Yeah, I think that I also agree that through educating legal aid organizations is another good aspect, because they're going to be getting inquiries about it. I think we did have the real estate conference in the last winter, and I was able to present on it to the real estate section of the State Bar. But I think to the extent we can continue to I think writing articles in Lawyers Weekly or PBA Journal, whatever, just to keep folks aware that this is a new development that will facilitate and assist. I think also the Farm Aid bill is another thing that a lot of folks aren't aware of. That it's part of the funding that's in that bill is with the loan program is really designed towards helping heir property owners to fix their heir property issues in terms of land management. And they actually did reforms that allow those who actually farm the land to qualify for loans, even if the property could be an heir's property with lots of different owners. If they can establish they're the ones working the land, I think that's even development under the Farm Aid bill. So I think educating Virginia farmers and landowners about those reforms that exist in that bill, I know that the adoption of the act is facilitating that to some extent, but I think there are also things in there already that they could make use of to obtain the financing to address, because it is the partition is still the best remedy for them. We've just improved the rules that govern that remedy, but the remedy is still the route to go for those who want to, if they can't get agreement and they can't reach a resolution through mediation, these new factors will favor those who have the most interest in the property, and not developers, not outside folks who might come in and try to take advantage of the discord within the family. It's going to favor those, and it's going to allow the allotment to be. When I gave the example of the allotment, I mean, if a developer were to try to buy a piece of an heir's interest, the way we have this act structured, the first remedy the court's going to look at is giving them the little piece for that piece, and so they're not going to disturb the vast part of the ownership. But if for any reason it can't be divided, then the allotment, they will not be favored in any allotment, and the allotment will favor the heirs, and they can be collectively so. In other words, the developer who might own 1/30 of the piece of tract of land, the allotment would say that the heirs, can collectively just buy out that 1/30 piece interest and continue on in the ownership they might want to keep it in. So I do think it's a really favorable, remedy now, more favorable remedy to getting these resolved. Whereas maybe before there might have been some hesitation to go into court, not knowing what a judge might do, given that we didn't have these reforms in place that provide the kind of guidance that favors those who own and work and their land.
There are a number of questions in chat about additional resources, and I just want to say thanks to Hallie and Marco, who have the last couple of weeks started pulling together a lot of frequently asked questions and links, and that will be part of the follow-up materials in addition to this recording. But that is hopefully will help for additional resources. I want to jump back to you, Ebony. There are a number of questions about the Farm Bill and what that really means in terms of heirs property. I think some of those questions are answered. Some of them are yet to be determined. But if you can give folks a little bit more background about why that Farm Bill is so important, and specifically about getting a farm number and clear title, that'd be great.
Okay. So in the 2018 Farm Bill, Congress gave FSA, Farm Services Administration or agency, I never can remember, the authority to issue a farm and tract number for heirs property. And what a farm and tract number does for a farm is, I call it the keys to the kingdom. If you have that farm and tract number, you can go into any department within USDA and access their services. Without it, you cannot. Historically, if you had heirs property, you could not get that farm and tract number, which means that you weren't able to access any of the programs that USDA offered. So that was one big plus. The other plus with it is that it provides a loan fund for people who want to resolve heirs property. That particular piece has not been finalized yet, but there will be a third-party lender who will provide loans. And the qualifications for that third-party lender is particularly important too, because it must be an organization that has 10 or more year history of making these types of loans. And what we're hoping is that whoever those lenders are will understand how to do the kind of loans that we need, which is going to be patient capital. It's going to have to be at low interest rates, and it's going to be able to be flexible. It may have to be redrafted. The loan may have to be recast on more than one occasion. So that's something that hasn't been worked out yet. And then finally, it also will give landowners who experience disasters from natural disasters access to USDA services that they didn't have before. The most important thing is the farm and tract number. Anyone who owns land and they're farming that land now and they don't have that farm and tract number, please make your way to the FSA office and do that as quickly as possible.
Okay, great. Ebony, also, I wanted to see if you would touch on a little bit. We have a number of very specific questions. This legislation is, as David talked about, trying to help improve an existing situation or kind of, stop some of the harm that's being done. But what really needs to be done is to resolve heirs property. Can you talk a little bit about the work of the future work of the Black Family Land Trust Legal Services and the efforts to train attorneys, and then maybe we can get into some of these specific questions.
Okay. So first, let me just say, for those of you who are not attorneys listening to this call, this is not a process that happens snap, crackle, and pop. This is, it is a very lengthy process. I think Ralph Sampson said it best when we were at the signing, that it was a painful process for his family because he has an aunt who he spent many summers with as a child that he knows he'll never speak to again, or she won't speak to him. And that is really hard for a family. So it's not a quick process. It can be a painful process. I think the more education you have and the more you talk with your family members and help them work through what their issues are about retaining the land or selling the land. The other thing is you will probably need some mediation to help you retain that. what we're doing with the BFLT is something that is kind of unique. We are working with the state bar to form a cadre of attorneys who will work with us on pro bono, low bono basis to resolve heirs property throughout Virginia. What we've done is we had our really big forming meeting last Friday. We're going to have a structure where we'll have someone who will act as chair and do some other things. But the key to it is that that individual, those lawyers will work with our families to resolve the heirs property. What the BFLT will do in order to help keep that cost down and time down that the attorneys will actually need to do is work with the families to get the family tree together, to work with the families to get the survey done, as well as to do the title work, to make sure that as we package all of the information and present it to an attorney, that we have as much of it done as possible, and the attorney can review and say, we need this, we need that, or we don't need that, and then do the rest of the legal work. We have been raising some money. We have a little pool of money set aside right now that can help us pay for the survey work as well as some of the title work. But having the survey and title are part of it. Our role is to work with the family to get the family tree together.
And what happens, Ebony, if you cannot track down all the family members?
I am not legally trained. I'm going to pass that off to David.
Yeah. So,
McClellan.
well, I mean, you do have the ability to proceed with them being unknown heirs. You can get a guardian ad litem appointed, usually for unknown parties who would represent their interests. I mean, the theory here, I think, is what, and Ebony's kind of alluding to it, is that when we think about those who like Senator McClellan said, benefited from land ownership and having access to education, lawyers, is that the land would have been passed to maybe the oldest son or something or whatever, but the ownership may have stayed in the family, but it wouldn't be owned by so many individuals. It would have been owned by a part of the family, and maybe other things were done for other members that didn't involve that land, or the land was, maybe it was different parcels that were separated, whatever. But the point is, folks who had the wealth and the access to education and legal resources, the land isn't owned by so many generations of people. So you're trying to do is if you can get through mediation, you can get a consensus. But if you can't even find all the people, then the remedy may be a partition where you try to allot the property to those who are working it, who are farming it, who are in the family. So you keep in the family, but you concentrate the ownership on those who really have an investment in it and are willing to the extent they need to pay to amount that would be then held in trust for those who have not been identified. So I mean, there's going to be a remedy. There is a remedy through the court, even when you can't track them. But you have to make a good faith. I mean, the court has to be persuaded that you've done everything you can to locate all those heirs. And then it gets hard when you have long generations, because then you don't even know who might exist out there to even find. So, but there are folks who specialize in this work, who locate, who do these heir searches. And it does cost money, and that's the point that Ebony was talking about. You do have to.
No, it can be
loans, to get. In certain cases, you may be kind of expensive to really to do that due diligence.
That's the biggest expense that we see, is identifying all, particularly when we have 3 or more generations, identifying and locating all of the heirs. And that is, as David said, a very expensive process, and one that we try to use our resources to help the family do. But again, that's why it's so important that you collect those documents, the obituaries, and having marriage licenses and divorce papers, and even wills, if you can find wills that people have that have been filed in the courthouse, looking at that. Those are all things that help you build that family tree and help identify who the heirs are.
So I don't know that we're going to get to all of the questions. I'm going to see if we can get to 2 or 3 more and then maybe ask our speakers to do a minute or two of wrap up. Senator McClellan, I do see a policy question from Chris Miller, and I'll ask that one to you. Has the General Assembly considered a mechanism for dealing with tax liens so that does not drive the partitioning?
So I think we have begun that conversation. I will admit we have an unusual session coming up that is going to still be virtual, that will have bill limits and may or may not be only 30 days. So I don't think that is something that's going to get traction in the 2021 session, but I do think that is a conversation that has started, and probably when we come back around to the next long session in 2022, I suspect you will see some legislation around that.
And Ellen, I could add that I believe Boyer Graves, I think Steve Price is heading a committee that, again, just like Senator McClellan said, everything's kind of held off a year. Boyer Graves wasn't able to meet this year, but I think next October, there's supposed to be a report from that committee as well, and maybe there will be some recommendations for the legislature in 2022. So we'll hope. I think it's something we have to keep working on, but I think the pandemic has caused some disruption in a lot of the efforts we're trying to do.
So I think for the unanswered questions, I think we will pull those and try to do a written response. I did want to mention that there are a couple folks on this call from the Richmond Federal Reserve. And part of what our work is certainly, through Ebony's work, to work one-on-one with landowners, but just to try and have a better sense of scale and understanding of heirs property in Virginia. And we are partnering with them to help map heirs property, hopefully over the next, I guess, 6 months to 2 years, to try and figure that out, really, how significant the problem is throughout the state. So I just wanted to recognize them and thank them for their partnership in joining this call, because as we have heard today, this is a incredibly complicated, deep-seated problem that is going to take all of us to work to try and figure out and resolve for families. With a few minutes left, I would just want to ask each of our speakers if they would be willing to speak for another minute or two, just kind of some final comments. And certainly there's a problem, but maybe how we move forward to work together to help resolve some of these issues.
I guess I'll jump in first. I think it is critical first to make sure that people know about and understand the transformative work that we've already done with this bill. And unfortunately, because of COVID, it has been more difficult to get information out about this legislation than normal. So we will get to you copies of the op-eds, which are all written not in lawyerese, to help make sure we spread that information. And then we will be monitoring going forward other things that we can do, such as dealing with the tax liens, to just making sure we can keep family land in the family, and make it that much harder for families to be exploited and lose this valuable asset.
One of the things that I always say is that land is a tangible asset, and if you take care of it, it will take care of you. It is also something that's very unique in the African American community, in that it connects us with our ancestors and our rich history throughout America. So we encourage everyone to look at land as an asset, to make sure that as you connect to that, you look at the spiritual connection that you have with the land, as well as the financial connection, and to think that you, if you have slavery in your family, and that land's been in your family since emancipation, are walking in the footsteps of your ancestors. It's one of the few places that we have in this country where we can actually say we're walking in our ancestors' footsteps. And that land is so important. It also is important because it can give you a foothold economically to ensure that the next generation has access to wealth.
And I just wanted to add, I mean, I did rush through very quickly this legislation, and I wanted to let you know it is attached to the materials that you have. And I also did a report that hopefully will be a better explanation than I was able to give so quickly. But really, I think that just continuing to work on this together, you know, as a group is really important. I'm happy to answer any questions offline. Anyone wants to call or email me. I'm still I care very much about this this issue and keeping to work on it. I'm also going to hopefully work with Steve Price on the tax lien issue and the tax sales. So I think we just have to keep addressing these problems and for administration of justice and fairness in our Commonwealth. So thank you all for participating today. I appreciate it.
Dan or Marco or Hallie, any final words to wrap up, logistics or anything else?
Again, I just welcome anyone to follow up with one of the partners hosting the webinar if you have any additional questions after you receive the materials, and we'll try to make sure you get your questions answered. And thanks to everyone who participated in the webinar, as well as our speakers and Senator McClellan for joining us. So.
And if you're an attorney, let us know if you're interested in working on this pro bono or low bono. So we are, Ebony, I think is maybe up to 25 attorneys or something like that, maybe more. And so trying to grow that group. So come on, let us know. So thank everyone. Thank you for all of our hosts. Everyone have a lovely afternoon, and information about this webinar will get out to you later, I think today or tomorrow. Thank you.
Thank you.